हेलो फ्रेंड्स, मैं आपका दोस्त डॉक्टर सजादवानी। आज के हमारे इस वीडियो का टॉपिक है राइट टू प्रॉपर्टी। मेरे ख्याल से राइट टू प्रॉपर्टी इज़ वन ऑफ द मोस्ट इम्पॉर्टेंट टॉपिक्स इन इंडियन पॉलिटी, और आई हैव ऑलवेज सीन क्वेश्चंस फ्रॉम दिस टॉपिक, वेदर इट इज़ अ पेपर ऑफ IAS or KS or JK SSB. One one or two MCQs are always asked from right to property. And a question can also be asked in KS or IAS means about right to property. So here it is. We'll start with right to property and its history. Originally, right to property was one of the 7 fundamental rights. जैसा कि आपको पता है that there are presently 6 fundamental rights in the Constitution of India, enshrined in Part 3 of the Constitution. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. And right to property was also a fundamental right in Part 3 of the Constitution. That means there were initially 7 fundamental rights, and at present there are only 6 fundamental rights. But right to property, it was enshrined in 2 provisions of the Constitution. One is Article 31, as you all know that, and the second one is Article 19, Clause 1, Subclause F. ये आपको याद रखना है. That means right to property, it was enshrined in 2 provisions of the Constitution. One is Article 31, the second one is Article 19, Clause 1, Subclause F. Article 19, Clause 1, Subclause F, it guaranteed to every citizen the right to acquire, hold and dispose of property. ये आपको याद रखना है. Article 19, Clause 1, Subclause F, it guaranteed to every citizen. आपको वैसे पता ही होगा that in Part 3 of the Constitution, that means fundamental rights, some fundamental rights are guaranteed to citizens only, while some other fundamental rights, they are guaranteed to everyone. That means whether a person is a citizen or not. Article 15, Article 16, Article 19, Article 29 and Article 30. These are the 5 articles under which the fundamental rights, they are guaranteed to citizens only. So Article 19, Clause 1, Subclause F, it is guaranteed to only the citizens of India that they have the right to acquire, hold and dispose of property. And later on this Article 19, Clause 1, Subclause F, it was later on deleted. So आपको याद रखना है, there are 5 articles in the Constitution in the part on fundamental rights, Article 15, 16, 19, 29 and 30, which are guaranteed to citizens only. उसके बाद Article 31, it guaranteed to every person, it's not the citizen. Person means whether a citizen or a non-citizen, that they have the right against deprivation of their property. That means it provided that no person shall be deprived of his property except by the authority of law. So under Article 31, every person, whether he is a citizen or not, he had the right that he shall not be deprived of his property except by the authority of law. That means only under the authority of law he could be deprived of his property. But there were 2 conditions. That means Article 31, it empowered only the state to acquire the property of a person on 2 conditions. ये याद रखना है. That means Article 31, it guaranteed to every person the right against the deprivation of his property. But there was only one exception, that he could be deprived of his property by the authority of law. That means it empowered the state. State किसको बोलते हैं? Under Article 12, the state has been defined here. I will not go into the detail of that. यहाँ पे इतना याद रखना है that the state has been empowered to acquire the property of a person only on 2 conditions. That means number 1, the acquisition of the property or the requisition of the property should be for the public purpose, and number 2, the state should provide for the payment of the amount of compensation to the owner. तो ये याद रखना है. That means यहाँ पे Article 19, Clause 1, Subclause F, it is guaranteed to every citizen, while Article 31, it was guaranteed to all the persons, whether citizens or not the citizen. Article 19, it guaranteed the freedom of acquisition, holding and disposing of the property. As you all know that in Article 19 there are still 6 freedoms: freedom of speech and expression, assembly, association, movement, residence and profession. उसके अलावा there was 7th freedom which was known as the freedom to acquire, hold and dispose of the property. उसके बाद आर्टिकल 31 में मैंने बोला that no person can be deprived of his property. The only exception is that he can be deprived of his property by the authority of law. लेकिन इसमें आपको याद रखना है that there are two conditions. That means only the state is empowered to acquire the property of a person if the acquisition is for public purpose and if the person or the landowner he is paid the compensation. तो ये आपको याद रखना है. So right to property, it was a controversial article. There was always a controversy between the Supreme Court and the Parliament. और right to property पे बहुत सारी confrontation हो गई है between the Supreme Court and the Parliament. There were litigations on the obligation of the state to pay compensation for the acquisition or requisition of the private property. When India became free, तो हमारा पहला मकसद क्या था? That was the development, and for development the state that needed the private property, और state the property acquire करना start कर दिया. लेकिन while the state acquired the property, there was always the litigation by the landowners that they are not paid the compensation. In fact, the state, whether it is parliament or the states, they made laws for the acquisition of private property, and these all laws, they were in the contravention of the fundamental rights. कैसे? Because right to property was a fundamental right, and when a person was deprived of his property through a law, through an act of the parliament or state legislature, these laws, they were in contravention with the fundamental rights, and the Supreme Court gave the judgments. The judgments were directed towards the government to pay for the compensation, and some of the judgments were directed towards the laws, that the laws were declared as void or unconstitutional because the laws for the acquisition of property were in contravention with the fundamental right to property. तो इसके रिटेलिएशन में पार्लियामेंट ने क्या किया? पार्लियामेंट ने इन चीज़ों को नलिफाई करने के लिए इट मेड द 1st, 4th, 7th, 25th, 39th, 40th and 42nd amendment in order to nullify the effects of Supreme Court decisions. It added Article 31A, Article 31B and Article 31C to nullify the effects of Supreme Court judgments and to protect certain laws from being challenged on the grounds of contravention of fundamental rights. आपको पता ही होगा Schedule 9, it protects certain laws which are made by the state or a parliament for the abolition of zamindari system, etc. These laws, they were in contravention with the fundamental right to property, and these laws were protected by an amendment made by the parliament by inserting Schedule 9. So आपको ये याद रखना है that right to property, it was a controversial article. So Supreme Court, it started giving decisions and judgments in favor of the landowners for the payment of compensation and for nullifying the laws made by the parliament which were in contravention with the fundamental rights. और parliament ने क्या किया? इन decisions को, इन judgments को nullify करने के लिए it amended the constitution because the parliament has the power to amend the constitution. और finally the parliament made a master stroke जिसको हम कहते हैं 44th Amendment Act of 1978. और इस amendment से क्या हुआ? The right to property as a fundamental right was repealed. Right to property खत्म हो गया. That means Article 19 Clause 1 Subclause F and Article 31 from Part 3 were deleted. Instead, it inserted a new article in the Constitution, that is Article 300A in Part 12 of the Constitution under the heading Right to Property. ये याद रखना है. Article 300A. Part 12 इसका टाइटल क्या है? फाइनेंस, प्रॉपर्टी, कॉन्ट्रैक्ट्स एंड सूट्स. Part 12 में 4 चैप्टर्स हैं. चौथा चैप्टर जो है इसका टाइटल है राइट टू प्रॉपर्टी, और चौथे चैप्टर में सिर्फ एक आर्टिकल है, दैट इज आर्टिकल 300A which was added by the 44th Amendment Act of 1978. और this article reads that no person shall be deprived of his property except by the authority of law. Wording तो इसकी सेम है as in Article 31, but here it is not a fundamental right anymore. So present position क्या है, that the right to property is a legal right or a constitutional right and it is no more a fundamental right, and also it is not a part of the basic structure of the constitution. That means it can be amended. तो इसकी implications क्या है? This is a very important point about right to property, that right to property, it can be regulated by an ordinary law because now it is not a fundamental right and it is not the basic part of the constitution. So it can be regulated by an ordinary law of the parliament and not necessarily by an amendment. Number 2, it protects private property against executive action only and not against legislative action, क्योंकि हमें पता है कि that fundamental rights, there are a limitation on the executive and legislative actions of the state. They are a limitation on the tyranny of the executive and the arbitrary laws made by the legislature. Since right to property is no more a fundamental right, so it can protect the private property only against the executive action and not against the legislative action. Number 3, in case of violation, the aggrieved person cannot directly move to Supreme Court under Article 32, but he can move to High Court under Article 226 because it's no more a fundamental right. In case of violation of fundamental rights, an aggrieved person, he can directly move to the Supreme Court. But since it's not a fundamental right anymore, so the aggrieved person may move to the High Court under Article 226 and not the Supreme Court. And the fourth point is that there is no guaranteed right of compensation, क्योंकि जब तक ये fundamental right था, there was a guarantee for the right of compensation. But अब क्योंकि ये एक legal right है, there is no guaranteed right to compensation in case of acquisition of the private property by the state. So these are the 4 implications. Right to compensation under Part 3 in case of acquisition of private property by the state. This time there are 2 provisions in the Constitution. This is a very important point. There are 2 provisions in the Constitution in Part 3, that means fundamental rights, which provide for the right to compensation. याद रखना है. Under Article 30 एक provision add हुआ था that when the state acquires the property of a minority education institution, we have to pay the compensation. This provision in Article 30, it was added by 44th Amendment Act of 1978. ये आपको याद रखना है, जब state property acquire करे of that of minority educational institution, it has to pay the compensation. Number 2, when the state acquires the land held by a person under his own cultivation and the land is within the statutory ceiling limits. When a person has a land and it is under his personal cultivation and it is within the ceiling limits as prescribed by the parliament, उस time भी when the state acquires that land, the state has to pay for the compensation. This Article 31A, it was added by the 17th Amendment Act of 1964. That means this provision was added by 17th Constitutional Amendment Act of 1964. So this is all about right to property. इस पे जो भी MCQs आएंगे, now you can answer those, and इस पे अगर descriptive question भी आए for KS or IS, you can answer that as well. So this is it. This is the right to property. If you have any queries, kindly mail me on sajadwani657@gmail. Follow my Facebook Genesis Academy, my Facebook profile Sajadwani, Instagram Dr. Sajadwani, and you can subscribe to my YouTube channel Genesis Academy by Dr. Sajadwani. Thank you so much for watching. Have a nice day.